Hello, and welcome to another webinar in Fieldfisher's Get Data Protection Feed series. My name is Nuria Pastor, and I am a director at Fieldfisher's Privacy, Security and Information Law team. And I'm joined today by Sebastian Georgescu, who is a solicitor in our team. Today, we will be talking about the one-stop shop concept under the GDPR. As those regular listeners amongst you will know, this webinar is part of our Get Data Protection Feed series. In previous modules of this series, we have covered the fundamentals of data protection law in Module 1 and putting data protection into practice, Module 2. So we are now on to Module 3, and we are talking about cross-border issues and data transfers. And this segment 4 of Module 3, we will be covering the one-stop shop and what's included under this mechanism. What are our learning outcomes? By the end of these sessions, you should be better able to understand what the one-stop shop is, the key concepts that you will need to consider when identifying your lead authority, and the instances where the one-stop shop does not apply. So let's start by considering what is the one-stop shop. Broadly speaking, the goal of the one-stop shop is to reduce the administrative burden of compliance for organizations that have a pan-European footprint and would otherwise need to interact with DPAs in each member state where they have a presence. Member states have their own independent supervisory authorities, in other words, DPAs, who are tasked with national policing, enforcement of, and compliance with data protection law. However, the one-stop shop provisions are intended to ensure that where a controller or processor carries out processing activities across multiple EU territories, it remains accountable only to one lead DPA. This means that for one-stop shop to be triggered, the organization's processing must have a cross-border element. In our next slides, we will take a closer look at what constitutes cross-border processing of personal data and how to identify your lead DPA. But before that, we will try to flesh out one-stop shop a bit more by looking at what it means, but also what it doesn't mean. I will now hand over to Sebastian for the next sections.
Thank you, Nuria. Now, as you can see from the table, the one-stop shop means that a lead DPA will be responsible for dealing with cross-border data processing activities and for coordinating cross-border investigations involving other DPAs. The lead DPA must also cooperate with other concerned DPAs. Now, to clarify this, one-stop shop does not mean that the controller or processor has a single supervisory authority to oversee all its processing activities in the EU. And this is an important point to note because it's a slight departure from what was the original vision behind the one-stop shop mechanism. And the reason why this is so is, as said previously, there may be other DPAs that are deemed to be concerned, and they will be involved in circumstances where either the controller or processor is established on the territory of the member state of those DPAs, or data subjects residing in the member states of those DPAs are substantially affected or likely to be substantially affected by the processing, or a complaint has been lodged with that DPA. So what is cross-border processing of personal data? Now, one-stop shop applies only where a single controller or processor has operations across more than one member state, or, if operating only in a single member state, that controller or processor engages in processing likely to substantially affect individuals in more than one member state. So what does that mean? Well, this means that where an organization has establishments in France and Romania, for example, and the processing of personal data takes place in the context of their activities, then this will constitute cross-border processing. Alternatively, the organization may only carry out processing activity in the context of its establishment in Romania. However, if the activity substantially affects or is likely to substantially affect data subjects in France and Romania, then this will also constitute cross-border processing. A conclusion that can be drawn from this is that not all multinational organizations with establishments in the EU may be able to benefit from the one-stop shop. For example, group companies whose group members each exercise individual decision-making power over their data processing activities will not benefit from the one-stop shop. So how do you identify your lead DPA? So to recap, the lead DPA is the supervising authority with the primary responsibility for dealing with a cross-border data processing activity and who will coordinate investigations where other concerned supervisory authorities are involved. So how do you actually go about identifying your lead DPA? Well, the lead DPA is the DPA from the controller or processor's single or main establishment in the European Union. Identifying the lead DPA therefore depends on understanding how to determine your main or single establishment. And we will move on to talk about how to determine this. But an important point to emphasize at this stage is that if you do not have an establishment in the EU, one-stop shop does not apply to you. Therefore, if you have a representative in a member state, that representative's mere presence in a member state is not enough to trigger the one-stop shop. Controllers without any establishment in the EU must deal with the DPAs in every member state in which they are active through their local representative and not through one-stop shop. So we've kept talking about it, and now for the big reveal. What is the main establishment? For controllers, the main establishment will be one of two. Generally, it will be the place of central administration of the data controller in the EU. There is an assumption that this is the place where decisions about the purposes and means of the processing of personal data are taken. However, if there is another place where the effective and real exercise of management activities happens, in other words, if decisions about the purposes and means of the processing of personal data are actually taken here, and this place has the power to have such decisions implemented, then this will be the main establishment. And to flag here, Recital 36 of the GDPR says that the presence and use of technical means and technologies for processing personal data or processing activities do not in themselves constitute a main establishment, and are therefore not determining criteria for a main establishment. For processors, the main establishment will be either the place of central administration or the establishment in the EU where the main processing activities take place. On the more practical side, some of the main type of questions that the lead DPAs may ask to determine what the main establishment is can include things like where is final sign-off on processing decisions given, where are business decisions that involve processing of personal data made, where is power to have decisions about these topics implemented, where is the controller or processor registered as a company, and finally, where are the directors with overall management of cross-border processing based? Now, to get to sort of the heart of this, does one-stop shop mean only one DPA? As you can see from the slides, not necessarily. Although being able to liaise with one DPA is the main benefit of one-stop shop, there are situations where multiple DPAs will be involved. In cases where decisions relating to different cross-border processing activities are taken within the EU central administration, there will be a single lead supervisory authority for the various data processing activities carried out by a multinational company, for example. However, There may be cases where an establishment other than the place of central administration makes autonomous decisions concerning the purposes and means of a specific processing activity. This means that there can be situations where more than one lead authority can be identified. For example, in the context of a multinational company, it's cases where that multinational company decides to have separate decision-making centers in different countries for different processing activities. There are also situations where other DPAs are linked to the processing operations, so-called concerned DPAs that was talked about previously. And these concerned DPAs can also be involved, for example, where the processing in question affects individuals in their local territories. Therefore, a key point to understand at this stage is that one-stop shop does not mean that a controller or processor will be in all circumstances answerable to only one DPA. Now, I will hand back to Nuria for a look at borderline cases and final conclusions.
Thank you, Sebastian. In cases where the controller or processor does not have either a place of central administration in the EU, nor an EU-based decision-making center, they will not be able to benefit from the one-stop-shop mechanism, unless the company designates one of its EU establishments to have the authority to implement decisions about the processing activities and be able to take liability for the processing, including having sufficient assets. Please remember, however, forum shopping is not permitted. If a company claims to have an establishment in the EU, but there is no effective and real exercise of management activity or decision-making over the processing, the DPAs will decide who the lead DPA is, based on the objective criteria and looking at the evidence. The lead DPA and concerned DPAs can rebut the controller's analysis based on an objective examination of the relevant facts and may request further information. This takes us to the end of our session. By now, you should be able to understand what the one-stop shop is, the key concepts that you will need to consider when identifying your lead authority, and the instances where the one-stop shop does not apply. This concludes our session on the one-stop shop. Thank you for listening.